Google versus Oracle. What the Supreme Court's ruling means for software IP protection under copyright law. Hi, my name is Yuri Eliezer and I'm with Founders Legal. Software has always held a strange and awkward place in copyright protection. Copyright protection, as of its foundation in the U.S. Constitution, was designed to protect non-functional works of authorship, like literature, artwork, and music. In 1979, Congress had decided that software source code, due to its typographical nature, would qualify for a similar scope of protection as literature under copyright law. Yet, if software is functional in nature, meaning it performs a useful action, why then would it be afforded protection under copyright law? After all, software function, regardless of the source code used to develop it, when deemed to be useful, novel, and non-obvious, is protectable under patent law. To obtain patent protection, applicants must go through a rigorous patent examination process designed to grant limited exclusivity to only certain inventions, the inner workings of which the inventors are willing to publicly disclose. That protection is further limited, lasting only 20 years, so the public can benefit from the technology and use it freely in the public domain after the 20-year period has expired. That's patent protection. In contrast, copyrights can last for well over a century and undergo almost no examination process. So we must be very careful in assessing the utilitarian nature of the subject matter which gets registered under copyright law. If it's not done right, we can have technology monopolized for much longer than is within the original constitutional intent or desirable public policy behind IP law. Again, so why would Congress issue copyright protection for software inventions? In fact, this very question is why this holding is of particular importance today. In this case, the Supreme Court does clearly specify the limits in the scope of copyright protection available to software. But what it does not do is address the actual legitimacy of software source code protection within copyright law in the first place. In fact, the Supreme Court specifically avoids the issue, stating in its opinion, and I quote, "To decide no more than is necessary to resolve this case, the court assumes, for argument's sake, that the copied lines can be copyrighted and focuses on whether Google's use of those lines was a fair use." This was not the court's ruling. So, before we dive into the case, here are the commonly accepted answers as to why software code is protected under copyright law. And these will help you better understand what the Supreme Court of the United States was grappling with. Some works are just too easy to copy. In fact, in the digital age, making copies of software is even easier than it was back in 1979. Since there was an element of authorship in coding, and that is, there's more than one way to express the source code to get the same functional result, Congress decided that the authors of the software source code were entitled to protection as authors, not just as inventors. Similar extensions of copyright protections have been extended to other functional devices, such as the design of an integrated circuit. Exceptions are typically reserved for those works that took much resource, engineering, and creativity, but are so easy to replicate once the final product is designed. The exceptions have an important exclusion that is governed by the Merger Doctrine. The Merger Doctrine states that when there is only one way to express the idea, fact, or function, meaning that there is no reasonable alternative available to achieve the same result, then copyright protection is not available to such an expression. So, common exceptions are for directories of IP addresses, email addresses, and phone numbers, or mathematics like abstract formulas. Although these expressions were really difficult to come up with and compile because there is no other way to express these ideas, facts, and functions, we do not provide copyright protection to such items. Instead, we must turn to patent law or trade secret governance for those. I hope you found this video informative. If you have any questions regarding software licenses, open source licenses, software copyrights, or software patents, feel free to reach out to the Founders Legal team.